Okay, everybody, we're going to start with Chapter 4, Experts, the right person for the right job. And a fantastic forensic fails videos. Shift Delete won't help you here. One of my favorite forensic videos goes through a bunch of fails. Really fun, really funny to watch. Really exciting stuff that they introduce and they go through, and it actually influences me later on to detail out some Outlook issues that you may run across. So this week we're going to have our discussion, Chapter 4, PowerPoint. The Chapter 4 discussion is going to be looking up e-discovery jobs and positions. What are some of the requirements for the positions? Where can you find a majority of these career opportunities? Is this something you'd be interested in as a career field choice? Why or why not? Don't forget to utilize MLA formatting when referencing positions or companies that are hiring those e-discovery professionals. Really exciting opportunities, especially if you are interested in the Houston area. Right away, when we search on Indeed, which is a great place to look for jobs, we can see an e-discovery support analyst in the Houston area right here through KL McKinney. So 2 years experience manipulating files, understanding of analytics, e-discovery review tools such as Relatively, IP Pro, Clearwell, Law, Summation, Concordance, etc. Etc. falls into the stuff we've been doing. All right. Experience providing customer support, troubleshooting, bachelor's degree or plus, so it's not mandated, meaning your associates can get you a job here. Litigation support or e-discovery experience is required. You get that here with this course. Computer skills, Windows, and Office Suite, including Access and Excel. All right, so Houston, pretty cool. Check it out. It's part of your discussion anyways. Case Project 4.3 or 4-3 is all about looking at metadata and removing hidden metadata and redacting PDF metadata. For this particular assignment, we're concerned with redacting PDF metadata, as well as the Microsoft.com Document Inspector. Really cool programs. For additional information, page 110 should give you that information. Your assignment is to write a short summary on your findings. So we'll flip back to Chapter 4 and start our lecture for the week here. Experts, the right person for the right job. We're basically going to summarize the developments in managing discovery, explain the roles in digital forensics consultants and examiners in civil and criminal cases, describe when to use consultants, including outsourcing factors, explain when to use special masters and forensics mediators, summarize the best practices in e-discovery team management. So managing e-discovery involves understanding processes and tools, skills, experts, and how to select the right expert. It also involves merging the two fields, law enforcement and information technology. Problems can often be avoided if IT staff has a reasonable grasp of litigation concepts and procedures. Law firms new to e-discovery often bring in an e-discovery attorney consultant with special knowledge of e-discovery processes and procedures. That consultant will help lead the attorney with technical wording in court filings and interpreting case law. It does not act to practical support in processing the case discovery, however. Alternative is to bring in an IT consultant at a lower cost and use an e-discovery attorney consultant only for law-related assistance. Also means you manage more than one. The Sedona Conference Guide, Best Practices and Selection of e-discovery Vendors, addresses how to choose e-discovery vendors and includes the Request for Proposal, RFP, and Request for Information, RFI. The EDRM offers Project Management Guide. It covers how a law firm's e-discovery team and corporate legal environment and vendors interact. These documents are written primarily for corporate civil litigation teams. Former Deputy Attorney David W. Ogden issued a memorandum to the DOJ called Guidance to Prosecutors Regarding Criminal Discovery. where it states the prosecution's duty for discovery and identifies the role of discovery coordinator in each U.S. Attorney's Office. With multiple defendants, one defendant may accuse another. They point the finger at another, and they, in turn, point the finger back. A defense coordinating attorney is used as a neutral resource between these multiple defendants, and it's in opposition to the prosecution. Again, defense, prosecution, pretty simple to understand that they are in opposition of prosecution. The coordinating attorney might act in a neutral position between all defendants, as well as being a neutral resource facilitator for the prosecution. An expert is someone who has special knowledge of a subject and can provide testimony. Not just an expert, but someone that can provide court reliable testimony, which comes from a study or education of experience and observation. To testify in court or depositions, expert witnesses must be qualified by the court. Consultants who give advice generally don't give a testimony, and may occasionally be asked to testify. However, at that time, they become an expert witness. E-discovery was received in the past by producing party-gathered documents. They were then assigned a Bates number and reviewed to see whether they contained information. If so, that material was redacted. Stuff that's private to a company's well-being or financial responsibility to their stakeholders or shareholders. Document information was entered in discovery and privilege logs and was then sent to the requesting party. Again, in the past, if it was complex, the lead attorney gathered groups of reviewers to go through lots of evidence page by page. Very time-consuming, very man-hour consuming, and it slowed the courts down. They then created and identified key information of each document, such as date, title, source, author, recipient, and other case issues. They were then often written on index cards, like this one. For Enron, the accounting number from the bag number 001, the N number 005, Enron accounting box 13. You can see what type it is. Complex systems of cross-referencing were developed to assist paralegals and attorneys in locating documents. They had notebooks prepared to organize copies of core evidence. At the trial, selected documents were presented to the jury on an overhead projector. Today, computers are more common. The automated litigation software is developed. Paper documents are usually scanned into an image format, usually TIFF, and then processed through OCR, or optical character recognition, where P becomes a P instead of a picture of a P, R becomes R instead of a picture of an R. And you can highlight them as they sit, copy, paste, whatever it may be. That's optical character recognition. And then they also convert word images into searchable text, which we just looked at. So if we were to look for text, there it is. We found text. We found 1 out of 1 in the entire document. Gathering discovery is now more complex. It involves digital forensics experts or web-based services. Previously entered on information cards, they're now in Word documents, captured digitally in a litigation database. Litigation software is effective only if the user has been well trained in the software's basic and advanced functions. Time and cost constraints often limit training. Lack of training creates problems in the form and errors as well on higher case and help elevate higher case costs because it takes longer to do when it should be simple. Law firms often seek experienced IT staff or legal trained staff in e-discovery processes and tools. IT staff can often search, organize, and process large volumes rapidly by using advanced database features and programming. Also important to know how to convert a wide variety of file formats into a form that can be viewed on a standard office computer. For example, IT skills might be needed to view the CAD, that's the computer-aided drafting, digital drawings, or geospatial maps. Digital forensics consultants and examiners are crucial to a successful litigation. They find, preserve, collect, and analyze digital evidence. Typically, they specialize in training. They have specialized trainings on computers, cell phones, audio, video systems, and other devices that hold evidence. Expert witnesses who identify and investigators who, what, when, where, and why, and how activities on digital devices. Discovery is the process of identifying, locating, securing, producing information and materials for the purpose of obtaining evidence for utilization in the legal process. Evidence is the testimony of witnesses, the introduction of records, documents, exhibits, objects, or other matters. In a civil case, discovery is generally done through interrogatories, requests for admission, requests for production, depositions after a complaint is filed. Interrogatories are written questions submitted to another party for the purpose of gathering discovery, written and answered under oath, or answered in writing, I should say. In criminal cases, discovery typically starts after a complaint or an indictment or an arrest. Digital forensics examiners are often involved with investigating this to get that indictment or initiate a criminal complaint. The trick here is don't focus on an indictment, focusing on the task or the facts, the FEARAC, if you remember. Conclusions should only be drawn based on the evidence, not whether or not the person is guilty. That breaches a code of ethics of an investigator. Digital evidence is seized when probable cause exists and a search warrant is issued. The use of digital forensics consultants in the civil sector is growing. Attorneys are becoming more knowledgeable about gathering and analyzing data. Digital forensics consultants might be involved in pre-litigation, corporate policymaking, post-litigation, expert witness services, how to identify what digital material should be subject to a hold notice, and how to comply with said hold notice. The Sarbanes-Oxley Act compliance family law cases. In civil role cases, they're basically looking for the first formal request, first formal discovery request. They can then advise the interrogatory's technical aspects for the case issues, such as questions on server backup frequency, storage, websites are hosted, frequency of password changes, etc. The request for admission is the written document asking the opposing party to accept or deny certain facts, generally served at the beginning of litigation, and the request for production is written request for information or discovery to be produced. Typically happens later. Deposition is taking the oral statement from a witness under oath before the trial. Digital forensics consultants can be deposed. A protective order limits access to information or evidence used in both civil and criminal cases. Documents filed with the court are a public record unless they are sealed from public access or protective under a protective order. In criminal cases, protective orders are applied to witnesses or informant identities to protect them from harm or intimidation or retaliation from the employer. Digital forensics consultants can identify what information should be protected. In criminal cases, commissioned law enforcement agents or agents perform digital forensics examinations and follow strict protocols. In some cases, they're carried out by officers who seize, they're carried out after officers seize digital devices. Initial law enforcement investigations rarely use consultants. Examiners are limited on an examination scope based on search warrant criteria. In some cases, a search warrant might not be required to seize a digital evidence. When it's in plain view, immediate seizure is allowed. Exigent circumstances exist when law enforcement believes evidence could be destroyed or safety risk to public or officers believed to be possible. There also might be an incident of arrest in which an arrest has taken place. Bill of particulars is used when defense attorneys get details and evidence of the alleged crime before arraignment, so defendants can be advised of plea options obtained after the complaint or indictment has been filed. A defense attorney might use these forensics consultants to review any digital evidence. A consultant used because defense attorneys rarely have forensics examiners as employed staff. In corporations, they might be asked to determine whether espionage has occurred, trade secrets stolen, or participate in network security policy making or incident response. Testimony by digital forensics consultants and examinators are in pretrial declarations, where a consultant might be asked to provide a written statement under oath to accompany that judgment or another motion. The summary judgment is the formal request of the judge to determine the facts of the case before trial, an attempt to erode the case bit by bit until no core issues are left for trial. Digital forensics consultants function as expert witnesses and can be disposed before a grand jury in order to get the indictment in criminal cases. Grand jury hearings are normally held in secret. The opposing side isn't usually present or aware of the hearing until the indictment is issued. The opposing side usually gets the digital forensics examiner testimony transcript under the Jenks Act. The Jenks Act is when the defendants in federal criminal case can use this act to discovery witness statements. Digital forensics examinators are asked for their qualifications when testifying as expert witnesses. The judge then makes the determination whether they're enough to be considered an expert. This process is referred to as the Daubert hearing. Expert testimony is usually permitted when it comes from a reasonably reliable source and can assist the jury or judge. So, training and expertise for digital forensics consultants, that may be another one for you to look into, e-discovery professionals, require tool-centered and academic training. Also, actual case experience helps gain a thorough knowledge of their specialties. Tool-centered training covers a wide variety of topics, forming from hexadecimal bit level analysis to user activity analysis. Law enforcement officers get digital forensics training from the International Association of Computer Investigative Service or Specialists, IACIS. In 2010, they offered the Certified Forensics Computer Examiner, CFCD. IT professionals already have a strong computer foundation, follow the training certification from a forensics software vendor. SANS Institute is a source of forensics education, and they also give fantastic newsletters if you subscribe to the SANS Institute. The Association of Computer Fraud Examiners has both beginning and advanced training, a continuing education option for Certified Fraud Examiner, CFE. CFEs are well-trained and investigated for fraud and detection. They specialize in digital forensics investigation and should not be viewed as a substitute for digital forensics certification. Licensed private investigators might be former law enforcement who have IACIS or certifications, training with a software vendor, or no forensics training at all. Each state has different private investigator licensing requirement. No consistency in background or training requirements. The transition to litigation databases used with e-discovery was gradual. Law firms were often slow to adopt this new technology. As discovery grew, the increase in computer-generated documents grew. Law firms began working closely with software developments to improve these litigation database tools. E-discovery consultants range from highly skilled attorneys with digital forensics backgrounds to poorly trained copy machine operators. With e-discovery consultants, law firms have established litigation support departments specializing in e-discovery. Many staff hold varying degrees of certifications and training. Ultimately, the American Bar Association or other credible association will likely identify bona fide certifications in this area. With consultants, we're talking about a wide variety of backgrounds and disciplines that might include digital forensics consultants and examinators. Few attorneys have formal training in digital forensics or IT fields. Attorneys who do have it can be a valuable asset. Attorneys who don't have specialized training but focus on e-discovery law use IT professionals to manage the technical aspects of the case. IT professionals began their career in in-house support at law firms and then move on to litigation support service providers or independent consultants. These support houses and web-based service providers are often extremely knowledgeable and experienced. They devote substantial resources to improving products and services and seek out IT professionals with law firm experience with a background in e-discovery. Digital forensics consultants are expanding services to include broader litigation support, like database management. Some consultants might have careers beginning as document reviewers and coders, then usually gain some type of certification. Large companies offer e-discovery and computer services like Kroll, OnTrack, IBM, Cisco, Pitney Bowes. Those large computer companies offer those forensics and computer services. Litigation software often offers two types of trainings: end user training and administrator training, where the end user prepares people to use the basic features and has limited technical skills. Administrator training is more complex, end user, as well as how to create a database and populate it with documents and data, managing backups, network security problems, and just the database in general. Academic institutions are establishing course to train law students, paralegals, and IT professionals, and that's exactly what we're doing here. Law schools tend to focus on e-discovery case law, but include limited orientation into litigation database and trial presentation tools. Courses offered by computer engineering departments tend to focus on technical aspects of e-discovery and digital forensics. Some 2 to 4 year colleges are working to form certificate programs for digital forensics and e-discovery, and Waco has that for you guys. The Advanced Technical Certificate for Digital Forensics includes 7 courses from collection, tools, special topics, criminal justice, analysis, and a comprehensive final project. Only held in Waco. For 21 credit hours, you can walk out with an Advanced Technical Certificate. The catch is, in order to get into this program, you have to have your associates in cybersecurity. Here at Fort Bend, your plan probably looks like this. These e-discovery consultants are sometimes asked to testify in court, though not as commonly as digital forensics consultants, and are usually their testimonies limited to methods they collect or use to collect the discovery. They don't really give analysis in court. They just said who did what and on what digital device. Outsourcing e-discovery consultants is a common practice until those vendors or in-house people gain the experience necessary. Outsourcing still requires knowledge of processes and tools, and many vendors outsource part of the process to foreign processing centers, such as document scanning and coding services. The quality assurance is very important here. Failure to ensure quality service could result in a higher case cost or adverse case outcomes, or overturning that case. In 2008, the American Bar Association issued the Formal Opinion 08-451, Lawyer's Obligation when Outsourcing Legal and Non-Legal Support Services, which places the responsibility directly on the attorney. Outsourcing is used in criminal courses, although less often because security, chain of custody, and other concerns. Special masters and forensics investigators. A special master is a person the court appoints to assist in performing specific functions, a neutral role between both parties, and may often be a lawyer or former judge. E-discovery and computer forensics masters can conduct on-site inspections of equipment and files and review sensitive data collections for relevance and privilege. In 2010, the Federal Court Law Review proposed the term forensics mediator for a new type of consultant, a person who would perform the actual discovery investigation instead of the plaintiff or defendant, will facilitate agreements on production between both parties and a possible solution to achieving full and fair discovery. The best practices for selecting a team, it's up to the clients to screen the law firms and consultants for suitable training and experience until the certifications have been approved by the American Bar Association. Then it'll probably move to a blanket. Smart Litigation Consumers establish best practice guidelines that combine certifications with ongoing training for all staff in the law firm. Law enforcement agencies who deal with discovery should stay up to date on new technologies and training. Many large companies require outside counsel to use task-based billing, commonly known as Uniform Task-Based Management System, or UTBMS. In task-based billing, each legal task is assigned to a code. The time spent on the task is logged into a billing system with that code. This allows the litigation client to determine how much time is spent on a major category of the process, including e-discovery. And in summation, we've got the organizational concepts of discovery are the same as today in the past. Index cards have been replaced with litigation databases. As the technology continues to develop, e-discovery becomes more complex. The industry has many consultants and experts, some with certification, some without. Tool Center training is available both e-discovery and digital forensics, where digital forensics training for law enforcement can be obtained from a variety of sources, the IACS and other independent agencies. Law enforcement still have the IACS with the International Society of Forensics Computer Examiners, the SANS Institute, the Academic Certified Fraud Examiners, and many more. Digital forensics examiners and consultants often testify in court for pre-trial proceedings. Law firms often outsource legal and non-legal support services, but remain responsible for the case overall. They use special masters, neutrals, and forensics mediators to keep civil and criminal cases with minimized disputes. UTBMS is a task-based billing system to create a narrative billing to establish cost and efficiency benchmarks. So that's all we've got today. Join us next week for Chapter 5.